So, friends, to finally talk about damages under Section 74 and to conclude the law on damages per se, you will notice that a genuine pre-estimate of the prospective damages is known as liquidated damages. Please note it has to be a genuine pre-estimate. If it's not, it could not amount to damages. It could actually amount to something excess of the same, which probably would be considered as a penalty. So you generally mention a genuine pre-estimate just to discourage a breach of contract, and that is something that you want to mention in the contract outrightly, and that's why sometimes this is permitted by law. And Section 74 also says that any interest on damages can be treated as penalty. This is something we will see through some of the case laws entirely. Now, in English law and in some other jurisdictions, you will notice that damages has its own position of law. However, in India, only reasonable compensation or what is mentioned in liquidated damages, if they're genuine and they're reasonable, that is the kind of upper limit of compensation that you can actually gain under the contract. Now, if you look at the case laws that have come into place, you will notice that in the Dunlop tire company was a new garage case. This was a case of resale price maintenance agreement. Today, resale price maintenance agreement can be covered under competition law as well. And Dunlop Tires had actually told its suppliers not to sell goods or tires below a listed price. And in case they did so, they would be imposed with a £5 penalty. So this is called the resale price maintenance. Now, when you or mention something in a contract that if you do or if you don't do, we will impose this kind of £5 penalty, then you will notice that this becomes a genuine pre-estimate of the kind of loss for the breach that is anticipated by the contract. So the court in this case had to decide whether the £5 that has been mentioned amounts to a penalty or liquidated damages, because penalty is usually a kind of in the nature of fine or in the nature of interest on damages. So the court had to decide these terms and conditions, and that's why you will notice that what the courts have laid down as test here becomes very relevant. It will be penalty if the stipulated sum is extravagant and unconscionable in amount in compared to the greatest loss that would have followed the breach. So anything that is over and above the kind of anticipated loss that you may put in a contract will be considered as penalty. It would be penalty if the breach consists not only of paying a sum of money and the sum of stipulated is greater than the sum which ought to have been paid. The penalty may be presumed when a single lump sum amount is payable by way of compensation on the occurrence of one or more several events, some of which may have a serious or other trifling damages. So anything that is over and above what is a genuine estimate of loss will amount to being called as a penalty. So the court held that it is evident that damage apprehended by the appellant owing to breaking of their agreement was indirect, not a direct damage. Because if you decide to say that, look, this is the price list and don't sell below it, you're controlling the price in the market. You're not allowing for competitive pricing. So are you really going to suffer loss if he sells you less than that price? You still mention it in the contract, but if you're not going to be able to substantiate that this is actually a £5 loss for every tire that is sold below a particular price, if you actually can display the same, then it would be liquidated damages, or else it could be held to be penalty, right? According to the agreement is headed as price maintenance agreement, they were held entitled to record to the same as damages, right? Now, the Fateh Chand versus Balkrishna Das case is also important from an Indian perspective. This was about earnest money that was actually asked at the time of execution of an agreement. Okay, so Balkrishna Das contracted to sell a leasehold right in a piece of land and in the building constructed thereon. So he received 1,000 rupees as earnest money deposit, and as per the contractual term, he further received 24,000 upon the delivery of the possession of the building and the land in his occupation to Fateh Chand. The sale was not completed before the expiry period stipulated in the agreement, and for this default, each party blamed the other. So this was actually a kind of a sale that was expected, and hence, the parties blamed that the sale did not take place. So, as per the term of the agreement, the contract stated that the executant shall be liable to pay a further sum of rupees 25,000 as damages, apart from the aforesaid sum of 25,000 to the vendee. In pursuance thereof, Balakrishna Das sought to forfeit the entire amount of 25,000 as liquidated damages and further made a claim of 25,000 from Fateh Chand. Now, when we say that this is the initial amount liquidated damages, and when you want to claim another 25,000, because it's in the nature of the contract and it is kind of pre-estimated in the contract, will you be entitled to the same, and can you forfeit if the contract is breached or if the contract has not been performed, maybe due to the fault of one of the parties or both the parties, right? That's one kind of an element in Fateh Chand that had to be decided in terms of the right of forfeiture, especially when advances are given in an agreement to sell or whenever contracts stipulate that the initial amount can be forfeited in case the contract does not get concluded. Now, if you look at the phrases or wordings of Section 74, it says whether or not actual damage or loss is proved to have been caused thereby, liquidated damages may be recoverable. The court held that that merely dispenses with the requirement of proof of actual loss or damage, but nonetheless the necessity that there is a legal injury suffered by the other party is a prerequisite in awarding the compensation under Section 74. So unless you can prove legal injury, whatever has been mentioned in the contract is not going to be recovered. So you will not be entitled to forfeit the entire amount. You will be probably entitled to forfeit only 1,000 rupees as earnest money, because the purpose of earnest money is only for that, right? So if you are able to prove, yes, my injury is 25,000 and that is something that I should have a right to, then you can always claim the same, is what the court had to say in that case. There are other cases, friends, as we see, which are also very relevant and important. This Mola-Bucks case is another very important case, and the principle in this case also reiterates the fact that the question is whether actual damage or the proof of loss is required under Section 74 or not. So the courts have been very, very sure of what they intend to do when they say that, look, unless you expect the word reasonable to be interpreted there, you cannot probably enforce liquidated damages. So liquidated damages cannot be anything that is written unless you can prove that why are you forfeiting the liquidated damages or seeking the liquidated damages. Your right to the same cannot be established, right? So liquidated damages in India is also compensatory in nature. It's based on your reasonable right to claim that kind of a money for the injury or the loss occurred to you, and the party claiming compensation must prove the loss suffered to him. So this has been laid down by the Supreme Court from time to time, saying that under Section 74 for liquidated damages, proof of loss or proof of injury to make the claim of compensation is very much essential. Unless that justification is made, just because it is mentioned in the contract, it will not entitle a party to recover the kind of damages that is there. Finally, in the ONGC versus Saw Pipes case, this is a very landmark case on many aspects, including on arbitration and public policy. The courts have said that you need to make a distinction between penalties and liquidated damages, because Section 74 does try to make that kind of a distinction. Anything that is, say, stipulated for time as the essence of a contract. Right now, in this case, you will notice I explained earlier how liquidated damages are going to be awarded. It is 1% of the contract value for the whole unit per week for delay thereof. This was agreed as a genuine pre-estimate of damages, and it also said that such maybe up to 10% of the contract value, and it was fixed for that day. Now, Enforcing such liquidated damages clause in the ONGC case was very, very important. This was something that was challenged in this case. The Supreme Court laid down the following principle, which I think is very important for us to understand. Now, the Supreme Court said if the parties knew that when they made the contract that a particular loss is likely to be the result of such a breach, they can agree for payment of such compensation. Right? In such a situation, the necessity of leading evidence is discretionary. Right? It may not be required in situation unless the court concludes that no loss is likely to occur because of the event which triggered the liquidated damage clause. So the point is that even if you mention any kind of liquidated damages, the courts are not entirely dispensing off with the fact that they need evidence or proof that this is the likely cause that is going to be affected through the delay. Delay itself is, if you prove, saying that, look, this was the time and this was the delay, that itself is a kind of a loss that you can probably claim in the court of law to claim any kind of reasonable amount of liquidated damages. The court went on to further hold that when parties have expressly agreed that recovery from the contractor for the breach of contract is pre-estimated genuine liquidated damages and is not by way of penalty. It has been duly agreed that it's not penalty, it is just a genuine pre-estimate. We are not imposing any fine on you. Then to that extent, proving any further loss may probably not be required. Right? So it is most importantly stated in situations where LD clauses is a pre-estimate, the burden would be on the other party to lead evidence for proving that no loss is likely to occur by such a breach. Right? So if there is LD clause, I have already informed you about time. If you don't supply within the time, I think the proof is on the other party to say why he caused the delay and why do you think his delay has not contributed to a loss to the other party. So shift the burden on the contract breaker or the one who has delayed the contract, and in case he is able to justify that the other party has not suffered any kind of loss, then probably LD will not be imposed, but the burden is on the other party to show that despite the fact that he had agreed to a particular time of delivery and he does not stick to that kind of delivery, the loss should be made recoverable from the other party. Finally, you will notice section 75. This very clearly gives the parties the right to compensation. So any person who has rightfully rescinded a contract is entitled to compensation, right? So if you have suffered any kind of injury to yourself or to your property, then you should be entitled to compensation. So one who has done equity can always do equity or claim equity under section 75 for the non-fulfillment of the obligation by the other party. Right? So this is something that is always as a matter of right. So damages is a right to a party rescinding the contract rightfully, and this is finally concluded under section 75 of the Indian Contract Law. So with this, friends, we conclude the discussion on law of damages. We try and understand the importance on law of damages as a remedy. We have discussed the rule of reasonableness, the rule of remoteness, the rule between direct and consequential losses. We have looked at how liquidated damages can be awarded if it's liquidated damages and not penalty. We have also looked whether the proof is required. We have said it is quite discretionary for the court to decide on the proof or lead the evidence. And the ONGC case very clearly puts a burden on the other party who has broken the contract due to delay that he has factored in because he knew that there is liquidated damage clause, despite the fact that he delays the delivery or beyond the schedule of the delivery. So the burden is on him to rather say that there was no loss occurred. And if he could do that, then LD may be in a pro rata basis. If not, whatever has been stipulated can be recovered under the contract law. So I think that is one thing that is very clear from the discussions that we have had so far. And the ONGC case, I think, rightfully decides the parameters of liquidated damages. And finally, I think the very broad provision is the person who rescinds a contract is entitled to compensation for the non-fulfillment of the contractual obligation. This is a matter of right that you can always claim. You can be compensated, and the term compensation here is quite wide. There is a loss, injury to you or your property, and you should be entitled to the same as probably damages under the law of contract. So if you make a claim, I think it is for the courts to use their discretionary power to grant you any kind of nominal damage that may actually amount to compensation for the other party breaking the contract.